may be seated. Good morning.
Good morning, Your Honor. This is the 10:30 calendar on July 24th, 2025. If we could take the Stetler matter first, in re the dependency of Freya Stetler, cause number 24-7-00352-31. Present for the record is Atharshna Singaraja. She represents the mother. The father is Jeffrey Stetler. He's present on Zoom. He is unrepresented, or he's pro se. Ann Bryce is Freya's A-gal. She's present in the courtroom. Janet Gross is covering for the ongoing caseworker Tammy Nichols. She's present in the courtroom, and I'm Sarish Khan representing the department. We are here regarding a dependency review hearing. At this time, the department has not received a notice of issues. The department is proposing a change in the permanency plan. Previously, the permanency plan was a primary plan of return home and an alternative plan of adoption or guardianship. The department is asking to switch those to a primary plan of either adoption or guardianship and an alternative plan of return home. The department is asking the court to make a finding that neither parent has made progress or compliance or have been compliant with court orders. Regarding visitation, the department is asking to maintain supervised visitation 2 hours 2 times a week for both parents. I do understand that Ms. Singaraja has a request that she would like to make regarding visitation, so I will let her address the court on that. But the department is at this time recommending supervised 2 hours 2 times a week. The mother has not been visiting so far. She did reach out to Ms. Nichols in June asking for visitation. Ms. Nichols is in the process of getting a visit provider for her. Hopefully one can be set up as soon as possible so that the mother can start her visitation. Regarding the father, Your Honor, he's had several visit providers. I believe that's pretty apparent in the court report. However, the visit providers tend to drop their referrals because of Mr. Stetler's communication with them. And so I believe at this time visits have been paused because there is no visit provider that's willing to take the matter. I understand that that's not an excuse to not provide visitation. However, the department is kind of at a weird crossroads because the department's not sure how to provide the court-ordered visitation due to Mr. Stetler's behavior. Regarding services, the department is not asking for any additional services. The services that were previously ordered is what the department is recommending at this time. The department does have a couple of requests for the court. One would be, as was apparent in Ms. Nichols' court report, as well as the documents that she submitted, Mr. Stetler has a history of sending very verbally abusive emails to the department, to the parties. In the past about month, he's tried to set hearings on the judge's civil motions calendar. Those have been continuously stricken by the court, the confirmations department at the downtown court. The department's request would be to either assign Mr. Stetler, at least standby counsel so that he has that assistance to be able to note his motions, to bring them properly before the court. I think that would possibly also assist with communication with the department and the parties if the communication goes through an attorney rather than Mr. Stetler. I understand that he does not want to be represented, but I think we're at that point where I'm not sure how to kind of progress with this case with the way things are without counsel for Mr. Stetler. And then the other request that the department is making is really for the court to order Mr. Stetler to stop with the abusive emails. And I think Ms. Nichols filed about 50 pages of emails, and I think that's just tip of the iceberg. It's a weekly thing that Mr. Stetler sends emails to the department and the parties that are not okay, to say lightly. So those are the two additional requests that the department is asking of the court at this time. Thank you.
Ms. Bryce, do you want me to hear you next or Ms. Singaraja next?
How about Ms. Singaraja, since she's going to be talking about mom's visits, and then I can respond to that.
All right, Ms. Singaraja.
Thank you, Your Honor. Tharshana Singaraja here on behalf of the mother. The mother is not present on Zoom because she was having technical issues. I just got off the phone with her a few minutes ago. Regarding the order, I did not file a notice of issues. However, just for the record, and I'm not contesting these, the mother is not in agreement with the findings of no progress and no compliance, and is not in agreement with the primary plan of adoption and guardianship with an alternative of return home. Regarding visitation, the mother is proposing 4 to 5 supervised visits, and if those visits have no safety concerns, then she is asking those to be changed to monitored. She is also asking for 2 in-person visits and 1 virtual visit. Because of her schedule right now, she's working multiple jobs. She a virtual visit, additional virtual visit will allow for additional contact with her child. However, that is all, and I would be approving the order as to form.
Ms. Bryce.
I guess I'd like clarification. Is the mother asking for 2 in-person visits a week along with a virtual visit a week?
Yes, that is what she is asking for. And additionally, what I forgot to tell the court earlier, the mother did reach out in the beginning of June to set up visitation. She was out of town prior to that. There's just been a lot of back and forth with the trying to reach a visit supervisor. And then I believe we heard from Ms. Nichols last week that a new visit referral was submitted. However, she did want the court to know that she was attempting to schedule visits over the past 2 months.
So just to make sure, the request is for 1 online and then 2 monitored visits a week. Is that was the request?
2 supervised, and then after 4 to 5 supervised visits, if there are no safety concerns, changing to monitored.
Ms. Bryce.
Yes, Your Honor. I'll start with regard to the mother. I've had some contact with her for the past couple of months. She typically calls me in a panic, wanting to set up visits. And I make sure that she has the department and her attorney's contact information. And then I follow up with her. And when I followed up with her, she's let me know that she wasn't available for a visit, or she was out of town, or that she's been busy working. So I just want to add that to the layer of information. I think that she does want to see her daughter. I've spoken with Freya, and Freya does want to see her mother. But I think we need to start out realistic about these visits, because again, I get a request about once a month for a visit, and then the mother is not available for the visits. So I truly hope that she is able to commit to a regular schedule. Consistency is definitely what Freya needs. She's already had a very difficult time with inconsistencies in the father's visitation, and I'm not blaming him for that. I want to be clear, but nevertheless, there are visits, not visits, visits, not visits, and that is very, very hard on her. She wants to see both of her parents. So I think we need to start out with a realistic schedule that the mother can actually do, so that we can build from there, so that we're not on this emotional, Freya is not on an emotional roller coaster. I am not opposed to the idea that after a certain number of visits, if they are out without incident, that they could move to monitored. Um, I don't know whether 4 to 5 is the right number because it has been so incredibly long since Freya has seen her mother. I would like to get some feedback from both Freya and her therapist
And her parent.
about all of this. So I am not willing to commit to just an X amount of number of visits before we do that. I think that there needs to be not just a
Objection.
quantitative, but a qualitative element to that calculation.
May I ask you a question?
Objection.
Would maybe starting with 1 per week?
Objection.
And whether, Mr. Settler, I'm gonna mute you for a minute because I need to talk to, Ms. Bryce. Ms. Bryce, so if starting with 1 per week, and if things, maybe if she can do that, for like 2 or 3 weeks, then have it, is that kind of what you're looking at?
Yes, yes, I want to make sure that we are successful because Freya needs to have some success. I'm not opposed to like 1 in person and 1 virtual a week.
Thank you. I didn't mean to interrupt you, but
No.
I did, sorry.
In terms of the father's situation, while he is verbally abusive, uses disgusting language, is juvenile in his tantruming, he is entitled to visits. He loves his daughter very much. She loves him very much. There needs to be visitation. I understand that the department has gone through a great number of visit supervisors and they have chosen to drop the contract because of Mr. Stetler. But that doesn't mean that they should not still provide visits. Even if it means that department staff is the one facilitating the visitation. Freya, again, loves her father very much. And they need to have visitation. I hope that he would consider the phrase, you get more flies with honey than with vinegar, in terms of moving
That's what it says in the
forward as to
Constitution.
the visit supervisors. I don't care what he says about me. I don't care what he says about the department, but the visit supervisors are people that are here to help him have visitation. I would expect, they have no say in the case. They follow strict instructions by the department. They are not
do.
decision makers in the case.
Yeah.
I hope that he would consider that, and when he is frustrated, direct his frustration elsewhere so that he is able to keep having visits and we don't have situations where people are dropping and then we can't find somebody to do it. So that on the visitation piece, I do think though that the department needs to, again, even if it's with their own staff, facilitate visits for him and his daughter. That waiting for a visit supervisor is, well, if they can't find someone, they have an obligation to come back before the court and explain the situation and not wait 4 to 5 months to bring it to court on a regularly scheduled matter. So I don't think that that is fair or appropriate to the family. In terms of standby counsel for Mr. Stetler, I'm not going to take a position about that, but I don't know if, standby counsel, if that's what they're labeled, if they would be able to really assist anything. It is I know that Mr. Stetler is frustrated that he has had a motion that he wants to bring before a judge about attorney's fees. I politely said to him that, like, you're noting it in the dependency case, you have to set it before the dependency judge. I really want him to have his hearing. I may disagree with what he is asking, but I want him to have his hearing. But he is intentionally choosing to do things that will not get his hearing, and then gets very frustrated and sends nasty messages to everybody, including poor court clerks that are just letting him know that the hearing can't be set on the calendar that he wants it to be set on. So I think it's worth a try to have standby counsel, to see if that, even if it's just that we get the hearings that he wants to have set, that might be some improvement in the situation. I agree that there's been no compliance, no progress for either parent with regards to services. I believe Mr. Stetler's position is that even before this case and the trial that he had, he is engaged in services. But after the trial, the court entered an order of services that he is supposed to participate in, and services done previous to that trial would not meet the court's expectation of he's now been ordered to do services. So I hope that he will do that. I do think that, again, just because he's verbally abusive to the department or other people, I don't see that verbal abuse towards his daughter. That being said, he places her in difficult positions because he talks about the case and expects her to be able to do things about the case when she's a child and she's really in no position to be able to do things that he wants. And I hope that he will remember that she is a child. She loves him very much. She wants to please him very much, but she's not in a position to solve his problems. That is not her job.
All right. Mr. Stetler, did you want to, I'm going to unmute your matter. Is there anything that you would like me to know, Mr. Stetler?
You catch more flies with honey than you do with vinegar. That is precisely the entire basis of this entire case. DCYF has not noted once in this entire matter how I am a danger to my child. It has always been, you are not nice to the social workers who kidnapped your child illegally. Judge O'Krent proved that in the trial. Said there was not one piece of evidence that required the removal of my daughter. So illegal removal. The next day, they had her medically raped under color of state. They had no reason to do so because their allegations were false in the beginning. Judge Scott, in the very beginning, admitted that the allegations were false, but because the false allegations contained the word sexual, it was required to kick this can 14 months down the road. So from which point, my daughter has been molested by her uncle, the first family shelter care family, who DCYF acknowledged on the 25th of April there is convicted child predators in that household. Braden Flowers, convicted 2022 for molesting his sister. They put my daughter in the same bedroom, acknowledging that. They conspired and colluded to cover that up and keep that evidence from me. Since then, DCYF has not obeyed one court order. They have obstructed visits from the month of May to June. And then when I caught Sean Walter, social worker, covering up the abuse and hitting of my daughter, they revoked visits for 3 solid months. They have not complied with one court order. They have not complied with one iota of the law, one iota of any kind of their own policy, and this court's orders. They have not complied once. Why am I to comply with orders set forth by a court that does not enforce their own orders? The visits have not been provided once. I'm supposed to have 2 hours twice a week. I've gotten a half an hour, maybe once a week. And my language towards the counsel, the opposing counsel, and DCYF is absolutely appropriate. If there were stronger language possible, I would use it, because there is no word in the English language that defines their abhorrent behavior of kidnapping and raping and torturing my child and trying to frame me for it. You think that it is okay to do this for profit, and DCYF just kicks the can? There's no problem with my filing techniques. There's no problem with my court calendaring. Every other case I've ever represented myself in, up to including like 40 of them, no problems whatsoever. It is only this case. Only this case. And the family law 481 motion is applicable under the judge's civil motion calendar. It has nothing to do with the custody of dependency or dependency at all. It is a financial matter that goes under judge's civil motion. The judges agree with that. The first clerk agreed with that. Riviera didn't want to hear it, so she kicked it down the road. And the guardian ad litem and opposing counsel here want to try it under you because they know you're not going to sign it, and they can be covered up, and there's no record of this proceedings whatsoever. And if you want to assign me another counsel, that's fine. That's another 4th, 5th, and 6th Amendment breach set on the federal court calendar.
So, Mr. Stetler, you sounds like you've indicated that you would be okay with a standby attorney who could help you.
That
So
it could
I
come to
will-
consequence. That was a causality statement. If you take away my rights, you'll be signing on that line that you're taking away my rights and breaching federal civil rights, Title 42, 4th, 5th, and 6th Amendments, and 14th Amendment.
Okay, so Mr. Stetler, are you telling me that you would like a standby
No,
attorney?
I'm not. I'm saying you are welcome to do whatever you want, but doing so will breach my rights. And
Okay, so I am going to have a standby attorney.
congratulations, you just
help
ended your
you.
career.
So I will indicate that he should have a standby attorney.
Now indicate the reason. Now indicate the evidence up to that, please, because you're going to have to report it in federal court.
So I've already made my decision on that issue. So Mr.
Okay.
Stetler, why don't you move on to the next?
Visitation. Why have you not enforced visitation?
Okay, well,
What danger am I to my child? What danger?
Okay,
What piece of evidence?
Okay, so my plan is to have visitation starting with 1 visit per week.
Nope. It's going to go up.
And then.
And it's not going to be in the middle of the day, so I have to take 2 days off of work to drive 200 fucking miles. This is obstruction.
Okay, so Mr. Stetler, I am setting the visits 1 per week. Is there a particular day that works best for you?
Saturday at my house. They will deliver her here. I'm not driving 200 miles. I'm not having obstruction. I'm not dealing with DCYF anymore. You're all going to prison.
So Mr. Stetler, hang on a second. I need to talk to
What danger am I to my child?
Department.
What evidence do you have of danger of me to my child? What drug test have I failed? What evidence is there?
What is your position on, I've ordered that we'll start with 1 per week. Where would that take place? I can't remember where Mr. Stetler lives.
Arlington.
He lives in Snohomish County. Freya is out on the Key Peninsula. It is not, I understand that it is very challenging for him to drive the distance. He has to drive all the way from the, Arlington area through Seattle, which has bad traffic, through Tacoma, which has bad traffic.
You just
I'm
cut
very
yourself a
sympathetic
fucking goddamn
to
case.
that. But I am not in agreement with Freya having to suffer through that traffic. Freya, again, is the child. He is a grown adult.
What does the fucking law say there, Guardian?
She should not have to suffer. That being said, Freya is transported to the coma office for the visits. So she does have a little bit of a drive, But to have
What does the
her,
law say about
go
visitation?
away to Arlington because it is a burden to Mr. Stetler.
Uh-huh.
It is
And what does
not
the
in the
law say?
child's best
Bitch.
interest. He has not presented any justification, any disability, or anything like
It's
that
the fucking
that would
law!
accommodate his needs over his daughter's.
So I will set the visitation as one per week in person, and it will be in Tacoma at the department there. And then there can also be one virtual, I think that's what you suggested, another one that would it be were you looking at a second one in person and one virtual every week?
Yes.
Okay.
Yes.
I will include that. I will order that. So Mr. Stetler, he's still here. So that's going to be 2 per week. One is virtual, and then one is back down in Tacoma. And that will be supervised.
Will it? Will they actually? You've ordered that for the last year, and they have not provided one. What enforcement
That
would
is
DCYF
another
have to make that happen?
exaggeration.
No,
I've
you let me
been
talk.
to one of Mr.
What
Stetler's visits.
guarantee?
I've been to one of your visits. You can't say there was none. I appreciate,
You're
though,
a
that
liar.
you have
Quit
not
muting me.
had all of the visitation, in part because it's a long drive, and so he frequently shows up an hour late. But they've waited for him so that he still gets some visitation. They've decided to not enforce the rule that if you're more
Name
than
me
15 minutes
one
late-
week where DCYF actually fulfilled the court orders. 1 week. You show me 1 week where DCYF has actually obeyed the court orders. 2 hours, twice a week. You show me 1 week.
Mr. Stetler, you have one in person, one virtual, so that's 2 per week.
They have not
Yeah,
been
2 per week.
obeying your court orders. They do not comply.
Mr. Stetler?
What assurances
you
do I
need
have
to-
that they will comply?
Mr. Stetler?
What assurances do I have that
ordered
they will
that.
comply?
Mr. Stetler, I've ordered it. And so.
What are
you can
your
make it
orders
happen.
doing? What good are
I
your
told
orders when
you.
they don't comply?
So, Mr.
They don't
Stetler, we're
comply.
not gonna
What
have
good
an
are your orders?
argument. It will be supervised and.
How are you going to enforce that? I need
I'm gonna-
stipulations.
If I could get some clarification, Mr. Stetler asked for Saturdays, the DCYF.
Stipulations. I need to know that they're going to be enforced.
Okay, you're saying that they're not available on Saturdays.
Then
The
that's their
offices are
problem.
closed over the weekend.
Mr. Stetler,
I have not had one
need you to
FTDM.
Stop
They have not.
talking over me.
They have not done the visits. You don't enforce your own orders.
So
They are
they're
obstructing.
not-
They are
Mr.
in contempt. They are in
Stetler,
contempt.
You cannot have visits on Saturdays or Sundays.
They can.
So-
They are in contempt. They owe me 400 hours. Contempt.
Okay, so they can't, which days do you want other than Saturday and Sunday?
Saturday and Sunday, unsupervised. Name me the danger to my child. Everything they say is he's not cooperative with the people who raped and kidnapped his daughter. No, I'm not. I'm not going to comply with terrorists. Tell me when their visit is going to take place and when it is going to be enforced.
So there will be 2 visits. There will be,
Not
during the
obstructing
week.
my job, not in the middle of the day. Not 14 hours
So,
away. The law
that's
says
my order
the visits are
on this
supposed to
matter.
be, the family, 1334 says the visits are supposed to take place at the parent's convenience to continue the family bond. That has not been enforced once. That has not been enforced once in this entire process. 400 hours they have
Also
deprived me of my daughter.
finding-
400 hours.
That he is not making progress. And he is,
You are not making progress. You cannot eye out one specific date. One specific date.
no progress and no compliance at this time.
No compliance, contempt of court, federal breach, $100 billion personal suit, Judge Dingletti, $1.5 trillion on the state. Sign it. Sign that fucking order.
Your Honor, is the court still ordering 2 hours for the visits?
contempt of court,
Yes.
kidnapping,
2
child
hours,
abuse,
yes.
child rape. Fuck you.
And
You're all
that's
going to
for both
terrorist prison. You're going to Guantanamo.
virtual or
Sign that order. Sign that unconstitutional order. You breach my rights. You kidnap a kid. You're responsible for this. You fucking child molesters. Yeah, Mr. Sneller does not fucking comply with terrorist bitches lying, cheating, stealing, and fucking kidnapping and raping children for money.
Ms. Singaraggio, did you have any?
Contempt of court.
You know?
Contempt of fucking court. Obey your own orders. When are you going to comply? DCYF has not complied once. What stipulations for DCYF to comply with the law? Mandate DCYF comply with their own law.
Your Honor,
show me evidence of any kind of. Show me evidence of abuse. Show me evidence. Reasons why to take. Reasons to take my child away. Reasons.
The mother requested an in-person and virtual visit, and the mother also requested a phased plan of after a couple of supervised visits, if there are no safety concerns, to change to a monitored visitation.
You're gonna have to kill me personally, Dinwiddie.
Sorry, I had it written, but I think I got a little distracted.
It's okay.
Your Honor, if I could address
Yes,
the mother.
I was going to come to you next.
Thank you.
See you in a minute.
Your Honor, regarding the mother's compliance in progress, the department is recommending no compliance in progress. The department hasn't had communication with the mother. She has, as far as the department is aware, has not participated in any services, and she has not participated in visitation. So the department's asking for no compliance and no progress. As for the visitation, Your Honor, I agree with Ms. Bryce in that I think because the mother hasn't had a lot of visitation with Freya,
the mother has an 18-year no contact order for taking her in front of child molesters, you fucking idiots. You didn't read your own parenting plan.
The department doesn't have an issue
read the parenting plan.
Visitation once the mother is visiting regularly with Freya. However,
mother is a drug addict and child rapist and abuser. She's lost 3 children.
It's difficult to put a
mother hasn't seen its kid in 7 years.
If visits are happening, we can always come back to court prior to the next review hearing and ask the court to amend that. The department can also
kicking the can illegally down the clock.
Liberalize
contempt and obstruction. Title 42. 14th Amendment. 4th Amendment.
At this time, the
6th Amendment.
That we
5th Amendment.
Supervised visitation.
Objection. 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 Unconstitutional objection.
At this time, the department is asking that visitations remain
6th Amendment
for the mother. If she is visiting regularly, the department.
1st Amendment, 4th Amendment, 5th Amendment, 8th, 9th, 11th, 14th, Title 42, 1334, all of it, 1334. Collusion, conspiracy, domestic terrorism, kidnapping, rape of a child, first degree undercover state.
Mr. Stetler,
rape of a child,
stop talking and listen.
You're not talking, I'm talking. You're unconstitutional. You're breaching your oath. You are not a judge. You're breaching your oath. Breach of your oath. Breach of your oath. Breach of your oath. Breach of your oath. You're a conspirator.
Stetler can see whether the department complied with
What's your oath? What's your oath, Judge? What's your oath to the Constitution? What is your oath? What is your oath, you junk? What is your oath?
Consistently.
What is your oath? What is your oath?
Visits.
What is your oath? What is your oath? What is your oath?
Said.
What is your oath? What is your oath?
I'm going to
what is your
out
oath?
of town for a significant period of time.
What is your oath?
Beginning of
what is your oath?
So
objection!
Like
Objection! Objection! Objection!
To do that
what is your oath?
On an off.
What is your fucking oath? What is your fucking oath?
The week
of
August 11th. That would be like maybe on the 14th.
What is your oath?
To see how a couple of weeks.
Oath to the Constitution. I swear on the penalty of perjury and death, I am not a communist. Oath to the state. What did you do to get your job?
I believe this is an
what is your oath?
the concerns that we have with regard to
Liberty!
their father and their
Justice!
daughter
Freedom!
is
Poverty!
not able
What
to
is your fucking
control
oath?
his emotions. That being said, he
I will
does
have you
not
removed by the U.S. Marines!
practice
What is your oath?
all of the time in his
Library's
visitation.
fine. You take me there.
He has
What is your
lost his
oath?
temper in
Yeah.
front of her, but not
What is your
towards
oath?
her. But he
What
does
is your oath?
pressure
What
her.
is your oath? You lying
For
lying
example,
murderer!
there was a birthday and he was
You
demanding
made
that
it so I
she
didn't go
tell
to
him
my
where
birthday
the
and you took the
visit was
business
to
away!
the
You
pizza.
garbage, you cunt!
And she was very scared about that and was worried that he would get in
I'm
trouble.
coming to
She
fucking
was
talk to you
actually
in person!
trying to
Cunt!
protect her father from himself
Fuck you!
within
Fuck you, you
not
lying
for
bitch!
God
Fuck
for
you!
the child, but
Fuck you!
he
What is your
can't
oath?
he can't get his way.
My
He's been
father's
trying
fucking
to
knows that my
get
way's the law, you bitch!
um,
It's the fucking law! When
he's
I ask in my
very
way, when you
emotionally
don't obey the
damaging
law,
to
you can take your
his
fucking
daughter to
gun!
see him
Fuck you!
his
Fuck you!
temper
Fuck you,
behavior in
constitutionally, bitch!
front of her
Fuck
towards
you!
other people.
You're going to prison, you fucking child rapist! You're going to fucking prison! Fuck you! It's not my way, it's
Right.
the law, you cunt! Law! You, under color of state, are not obeying the fucking law that you fucking swore to! Not me, not my way, the fucking law! It's the fucking goddamn